This is number 10 on the calendar, State of Washington versus Andre Philip Karlow, cause number 241065969. Timothy Shen appearing on behalf of the state.
Good morning, Your Honor. Jordan Murad given on behalf of Mr. Karlow. And for the purposes of this hearing only, we'll stipulate to name and date of birth.
Thank you. Okay. This is number 10 on the calendar, State of Washington versus Andre Philip Karlow, cause number 241065969. Timothy Shen appearing on behalf of the state.
Good morning, Your Honor. Jordan Murad given on behalf of Mr. Karlow. And for the purposes of this hearing only, we'll stipulate to name and date of birth.
Thank you. Sir, your attorney, having stipulated to your name and date of birth for the purpose of this hearing, you've been charged by way of information with one count of a hate crime. This is alleged to have occurred on or about September 14th, 2024 in King County, Washington. A copy of the information has been provided to your attorney. I ask now whether he will acknowledge receipt, waive any further formal reading, and enter a plea on your behalf at this time.
We'll acknowledge receipt, waive formal reading, and enter a plea of not guilty.
Plea of not guilty is entered.
And Your Honor, we would like to be heard on release.
Proceed.
So, Your Honor, we are asking the court to release Mr. Karlow in his personal recognizance. I want to first address the state's contention that Mr. Karlow presents a danger to the community. I want to note that Mr. Karlow's last convictions were in 2019, and those were for essentially driving charges. What I'm seeing is that his last felony was in 2008. That's 16 years ago from today. And I also want to note that the nature of this case, and again, we're not stipulating to any of it, of course, but the allegation is essentially a simple assault. And of course, there's an allegation that Mr. Karlow used a slur. And while that's all contested, I want to note that while it's a horrible, horrible thing to say, that the homophobic slur in question is kind of a common schoolyard epithet, and it's used with more generalized intent and not really with any specific intent towards the recipient. That's just frankly some of the vernacular that's unfortunately used by some people, especially in heated situations, but it's not directed towards someone because of their sexual orientation. It's kind of interchangeable with other more, I think, generalized curses that people use sometimes. I also want to address for the court the warrants here, and I looked at, both of these are out of Renton. JABS reflects that in April of 2024, and looking at the cause number 4A0178379. In April of 2024, Mr. Karlow's notice of arraignment was returned to sender. I don't think he had notice of that. That being said, he did arrange to come in and address his warrant in June of 2024. JABS reflects that Mr. Karlow notified the court he had a medical incident and would not be able to attend, and that he actually did follow up with proof of his medical visit. In July of 2024, it does say that Mr. Karlow was in attendance by Zoom for his bench warrant quash hearing. According to Mr. Karlow I've spoken with, the court had denied his request for a public defender and told him to hire one, which he's unable to do so. And Mr. Karlow did not want to proceed.
What was that jurisdiction again?
This is Renton. And Mr. Karlow, he didn't want to proceed pro se, representing himself without the assistance of an attorney. And so I understand that those are outstanding warrants, but he's trying to figure out how to get representation down there to address these cases. He's aware of them, and he wants to address them immediately upon resolving, release from this case. I also want to note his ties to the community. He stays with his partner, Samantha Fair. She's actually present here in the gallery today. She came to support him, and she's out there, Your Honor. She was with him at the time of this alleged incident. They live locally here in Seattle. I also believe that Mr. Karlow's aunt, who does live in Chicago, may be on Zoom right now. And again, they're here in support. He has a support system in place. Mr. Karlow has an 8-year-old son. It's imperative he needs to be able to see his son out of custody. And Mr. Karlow is frankly on the way towards greater stability in his life. He has already enrolled in a pre-apprentice construction program. This is at the Wood Center. This is on 23rd in Jackson. It's a well-established program. He also has medical issues that are not going to be attended to appropriately in custody. He's already been approved for age-blind disabled, in part because he suffers from severe PTSD. And it's imperative that he's released so he can receive treatment in the community to maintain his mental and physical health. Finally, I would note Mr. Karlow, he has a phone, he has an email, he'll be able to maintain contact with me. And for all those reasons, we are asking the court to release him.
State, can I see an appendix, please?
Yes, Your Honor. I'm going to get the appendix to you now. Your Honor, the state is asking for the $30,000 in bail to be maintained. The state has very serious concerns for community safety here and victim safety. I just want to first address counsel's argument that this is more of a schoolyard type insult. I don't think that argument is appropriate here. This isn't trial. Further, it is not a schoolyard insult. It's, I think, well recognized today that it's like one of the most vile words you can call someone who is of that community. Further, Mr. Karlow was not in a schoolyard. He was at a light rail station. He is not a child. He is a 30-something-year-old adult. And so to, I think, equate this to a schoolyard insult really doesn't carry the water here for lessening any of the state's concerns for community safety and victim safety, in particular because the victim in this case appears to have been targeted because of the way they present their gender identity. And we have tens of thousands of people who live like that or who are that way in Seattle. And so for the community safety reasons for those folks as well, the state thinks that bail is necessary and appropriate. Further, it's not just that he used this slur, he also punched the victim in the face. It's more than just a simple assault here. It is, we are here for the underlying fact that the person's gender identity seems to have been the motivating factor in this assault. Further, the state does have concerns that he will not appear for court. He does have, by the state's count, 31 failures to appear since 2002. And on the 2 open Renton municipal warrants, the state acknowledges that he shouldn't have to go through any of those proceedings without an attorney. He still knew they were out there. He still knew they were occurring. He still had an obligation to show up, and that doesn't lessen just because he seems to have misunderstood how to get a public defender. And so for these reasons, the state does believe that bail is necessary to ensure community safety and his appearance in court. Thank you.
Thanks.
Your Honor, I'll rely on my previous argument, which I think addressed those points.
Looking at the facts alleged, without getting into the nature of the use of the words, it was such an allegedly unprovoked act for no reason. It appears that Mr. Karlow is a danger to others, and I think only detention would resolve it. I'm going to deny the motion.
And Your Honor, would the court consider lowering bail given Mr. Karlow doesn't have a present, he doesn't have a job right now. He is, again, trying to get into the Wood Center's pre-apprentice program. But he does have this ABD benefit, and considering his indigency, would the court consider a lower bail?
I'll amend it to $30,000 surety or $3,000 cash.
Your Honor, the state is also asking for an order prohibiting contact with the named victim.
So ordered.
With that in mind, speedy trial will commence today, October 2nd, 2024. Omnibus, October 23rd, 2024. Trial, November 20th, 2024. Speedy trial to expire on December 2nd, 2024.
That's fine.